Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. In today's class, I will discuss an important case wherein the accused has been discharged by Honorable High Court and proceedings are set aside and quashed. Please note down the name of judgment. Judgment name is C.K. Prasad versus State of Kerala. Judgment is pronounced by Honorable Kerala High Court. In that case, a petition was filed before Honorable High Court as per section 528 of BENSS. As we know that the said protocol is inter alia deal with the inherent power of the High Court. It says that nothing contained in BNSS, the High Court could exercise the inherent power to do the justice and apart from that to prevent the abuse of process. The allegations against the accused persons were that they abused their official position. The allegation was that certain price was fixed regarding the commodity, but without executing the proper agreement and without collecting the proper tax, they inter alia provided undue benefit to the concerned beneficiaries and ultimately they cheated the government and wrongful loss has been caused to the government. It is submitted by the prosecution that they have committed the offence as per section 13 subclause 1 subclause C of PC Act, and apart from that they violated section 409, section 420, section 120B of IPC. The concerned petitioner submitted that basically the allegation of prosecution is that we failed to collect the stamp duty and taxes, and that's why we had been prosecuted on ground that due to the said act the loss has been caused to the government, and apart from that the act comes with the preview of cheating. It is submitted that the accused number 1 is president, means adhyaksh of the panchayat, and the work of tax collection is not the duty of president of the panchayat. And apart from that, the accused number 2 is not required to take decision regarding the execution of agreement and collection of tax. Basically, the work is of CEO, and even the work is not allotted to them. In that scenario, it could not be said that they have abused their official function. So, to prosecute the accused person for criminal misconduct, it is shown that he is assigned with a public duty and he discharged the official function in the undue way to obtain the undue advantage for himself. So, by the bare perusal of the entire FIR, the pinpoint case is that the concerned accused person failed to collect the tax, and apart from that, they failed to execute the agreement. But collection of tax and execution of agreement is concerned with the work of CEO. It is not the work of president or the concerned official, that is A2. In that scenario, in absence of a public duty and competency of work, the charges could not be framed. And finally, the petition succeeded and accused got discharged. So whenever we are entangled in the said scenario, simply we have to follow the 5 important principles. First of all, we have to read the FIR and find out our specific role. Number 2, submit the representation. In case the authority failed to consider your representation, in that scenario you could get the benefit, so that we could specify to the concerned court that on the factual score, on the legal score, the IO is not willing to investigate, and that's why we could chalk out the case for unfair investigation and could proceed accordingly. Point number 4, sometimes it is seen that in the anxiety we move for the quashing, but without any basis we cannot move for the quashing, because quashing is concerned with the inherent jurisdiction of the Honorable High Court. Simply we have to show the abuse of process. So to showing the abuse of process, simply we have to specify that the facts available on the record entirely indicate that the continuance of the proceeding is not permissible. In the present case, it is submitted that, as I told you earlier, the work is not pending. So if the work is not pending, it is not assigned. In that scenario, there is no question to abuse the official position. So the proceeding appears to be abuse of process. So in that scenario, the questioning proceedings appears to be appropriate. So if you are having the same scenario, you can follow the same track. Last but not least, whenever we submit the case before the Honorable High Court, just pinpoint your case, because Honorable High Courts are already overburdened, and if they will give you more and more time, then what about other cases? So pinpoint your case as per the FIR, pinpoint your case as per the representation, and apart from that, if there is any evidence or corroboration to support your claim, you may also pinpoint the same in the synopsis, and apart from that, you have to specify the legal position against which the prosecution has been initiated. In that scenario, you could chalk out a good case for questioning before the Honorable High Court. See you in the next video. Till then, Jai Hind, Jai Bharat.